We reverse the order quashing an out-of-state administrative writ of withholding for child support and remand for further proceedings. The events leading up to the issuance of the appealed order began in 1997 when Joan S. Hedge, the mother and resident of Texas, filed a notice of registration of a Texas child support order in Florida. Pursuant to Section 88.351 of the Florida statutes, the State of Florida Department of Revenue filed a petition on behalf of Joan S. Hedge, the mother. Dale E. Hedge, the father and resident of Florida, answered and filed a counter petition for modification of child support in September 1997, along with discovery requests. His answer disputed the arrearage alleged in the notice and requested that the Florida court determine the amount. He later filed a separate petition for relief, reiterating the request for a determination of the arrearage. Because the mother refused to cooperate with discovery, the Department of Revenue voluntarily dismissed the action without prejudice in 1998. Although the petition was voluntarily dismissed without prejudice in 1998, the trial court held a hearing on its sua sponte motion to dismiss petitioner's action in May of 2000. As sanctions for Joanna Hedge not participating in discovery, the trial court dismissed with prejudice the action for enforcement of arrears, and the action June 2000 order was that the June 2000 order was not appealed. Apparently, as a result of the trial court's actions, the father voluntarily dismissed his counter-petition without prejudice on the same day as the hearing. In December of 2000, the state of Texas issued a notice of administrative writ of withholding directed to the father's Florida employer, as permitted under Section 88.5011 of the Florida statutes. The writ sought garnishment of the father's pay for his current child support obligation, as well as the disputed arrears under the Texas child support order that was the basis for the earlier Florida action. In response, the employer filed a motion for protective order, and the father filed a motion to quash the Texas writ of withholding on the grounds that the Florida trial court's June 2000 order dismissed with prejudice the enforcement of the alleged Texas arrears. After a hearing on the motions, the trial court denied the employer's protective order, enforced the Texas writ of withholding with regard to current child support, but quashed the writ with regard to the arrears. The trial court ruled that res judicata barred the enforcement of arrears, relying on its June 2000 order dismissing with prejudice the action to collect the arrears. Joan S. Hedge and the Department of Revenue appeal the December 2000 order. We reverse. When the trial court dismissed the action with prejudice in the June 2000 order, the appellants were no longer before the court, since they took a voluntary dismissal 2 years earlier. Thus, the order dismissing the action with prejudice was void for lack of personal jurisdiction. Therefore, the trial court erroneously relied upon its June 2000 order as a basis for res judicata. Although the June 2000 order is not before us, and in this appeal, any competent court may adjudicate an order void for lack of jurisdiction over parties or subject matter. See Gay versus McLaughlin, 105 Southern Reports, 2nd, 771, Florida, 1958. The trial court simply had no personal jurisdiction regarding the action that had already been voluntarily dismissed without prejudice 2 years previously. The father contends that the petition for relief constitutes a counterclaim that bars a voluntarily dismissed order of the court under Rule 1.4 of the Florida Rules of Civil Procedure. The petition for relief, however, appears to be a contest to the registration of the Texas Child Support Order as specifically authorized by Section 88.371 Florida Statutes 1997. Thus, that petition was not a counterclaim seeking affirmative relief that would trigger Rule 1.420. $135. How do you get that?
Okay.
Can you tell the difference between 120 and 135? You take it?
Not really.
It's right in, you're not falling asleep.